Good afternoon, everyone. I want to thank you for joining us with this webinar hosted by the Canadian International Internet Dispute Resolution Centre, or CIIDRC for short. We are a subset of the Vancouver International Arbitration Centre, located in Vancouver, but serving the world, courtesy of the internet. The Vancouver International Arbitration Centre, previously known as the British Columbia International Commercial Arbitration Centre, was established in 1986 in order to help facilitate the growth of Vancouver as an international financial center, coinciding with Expo 86 at that time. It was supported by both the provincial government in British Columbia and the federal government in Canada as a major initiative to support Canada becoming more involved in international arbitrations. Fast forward to today, the CIIDRC was established in 2019, serving the UDRP rules through ICANN, after many years of us providing service to the Canadian Internet Registration Authority, CIRA, facilitating disputes regarding domain names with .ca. So fast forward to today, we're hosting this webinar with some learned counsel and esteemed members who will talk to us about relevant and emerging issues in pertaining to internet domain name disputes. Joining us on this panel today is Zach Moskovich, a Canadian lawyer who's acted in domain name disputes since 1999. Zach has acted on counsel both for claimants and respondents in over 100 contested UDRP, CDRP, and other national domain name dispute mechanisms. In addition to domain name arbitration work, Zach has acted as counsel in several precedent-setting domain name dispute court cases in the Ontario Superior Court, and in the Federal Court of Canada. Zach is active in internet governance issues through his work with ICANN, including Rights Protection Mechanisms Working Group and the Transfer Policy Working Group. Zach has recently been appointed as a panelist to the CIIDRC, and we're glad to have him aboard. Stephen Levy, Esquire, has been practicing in the field of trademark law for over 30 years and has filed over 550 domain name complaints. He has been involved in nearly 500 domain name cases as a party representative and has more recently decided over 100 cases as a UDRP panelist. He's been a panelist for 7 years and is on the roster of neutrals for the Forum, CIIDRC, that's us, and the Czech Arbitration Court, and the Asia Domain Name Dispute Resolution Center. Mr. Levy is also a member of the ICANN Working Group for Review of Rights Protection Mechanisms and has frequently written and spoken on the topic of domain name disputes. And then lastly, but not least, we have Dr. Gerald Levine, an arbitrator for the American Arbitration Association, Financial Industry Regulatory Authority, FINRA, and for cyber squatting disputes, he is a panelist on the roster of neutrals for the Forum, CIIDRC, the Czech Arbitration Court, and a nominator panelist for the World Intellectual Property Organization, better known as WIPO. His essays on trademarks, domain names, and cyber squatting have appeared in both print and online journals. He is the author of a treatise on trademarks, domain names, and cyber squatting, and of various publications. A new book, Clash of Trademarks and Domain Names on the Internet, is scheduled for publication this fall. So with that, I encourage all of you to, if you have questions, to put your comments in the comment section. I will attempt to moderate those questions and direct traffic. And I should also note that this session has been approved for 1.5 hours of continuing professional development credit by the Law Society of British Columbia. Just give us a day or two, or the Law Society a day or two, to get that processed and up on their website, so it's an available option for you to record your time. And with that, I'd like to turn it over to our panelists.
Barry, thank you for the introduction. Steve, Zach, and I really appreciate Cedric inviting us. So let me quickly map out our plan for this afternoon. We're not going to be lecturing you. The three of us are going to have a conversation about the UDRP. If you've listened to Neil Brown's inspiring Cedric talk a few months ago, you will have learned that the UDRP has a three-part structure and that the complainant has the burden to prove its case. It is only on the fulfillment of their separate evidentiary burdens that a party succeeds in proving or defending against a claim of cybersquatting. We're going to talk about burdens because not everyone pays attention to what they are. We have in mind a particular reason for doing this. We want you to imagine that a client has come to you with a cybersquatting case. The client could be a rights holder or a registrant who has received a UDRP complaint seeking to deprive it of a valuable domain name. You now have to draft a complaint or a response to a complaint. Even though providers such as CIDRC have forms that assist draftspersons in preparing complaints and responses, these forms do not tell you how to craft your pleading. But one thing is certain, in performing your task, you must marshal evidence to prove your claim or defense. You will have learned from Neil Brown's talk that the burden shifts to respondent if complainant's proof is persuasive. And if it is persuasive, respondent has a rebuttal burden. We will be talking about marshalling evidence and the circumstances that support or undermine parties' contentions and arguments. We're going to tell you that UDRP pleadings are very unlike complaints in civil cases. They are more akin to motions for summary judgment. And if you proceed with drafting a complaint or response without understanding this, you're going to be in trouble. Because it is your task to present a coherent case for your client, our focus will be on pleadings and proof. We're going to underscore that the UDRP has a well-developed jurisprudence. We believe that it is not enough for you to be familiar only with the text of the UDRP. You also have to be familiar with the constructions that have been accepted as precedent over the past 20 years. The first item of discussion will be the draftsperson's responsibility for filing truthful pleadings. The consequences for failing to do so are of two kinds. The first affects the outcome of the case on the merits, and the second primarily affects complainant, which we will discuss. We're going to start off with reverse domain name hijacking, not for its substance, which we'll deal with at the end of our discussion, but for the certification of Steve. Steve?
Well, thank you, Jerry. You were breaking up there for a second, but I believe you introduced me. Yeah, the reason we're starting with reverse domain hijacking is sort of as a cautionary tale. As panelists, we see all the time that complaints are filed, and sometimes by rather junior associates at a firm or by folks who have no training or familiarity, and sometimes key and critical things are overlooked. So the last thing you want is to take a perfectly good case and either lose it and also be found guilty of reverse domain hijacking. And so we're clear, reverse domain hijacking is found under Rule 1 of the policy, the definition under Rule 1. And it's basically using the policy in bad faith to attempt to deprive a domain name holder of a domain name. And if you look at Rule 15E, and by the way, the rules are in the companion materials that we've submitted for this presentation. So under Rule 15E, the panel has the authority to decide that the complaint was brought in bad faith in an attempt at reverse domain hijacking. And we sometimes call it RDNH, so you'll hear that acronym a lot. So it was brought in an attempt at reverse domain hijacking or primarily to harass the domain name holder. And it was an abuse of the administrative proceeding. So the penalty of RDNH can also be tied, as Jerry alluded to the certification requirement. Both parties, the complainant and the respondent, again, if you're going to follow along under Rule 3C for complainants and for respondents, it's Rule 5C, Roman 8. But the pleadings, you have to sign that certification that the pleading is, quote, complete and accurate, and is not being presented for any improper purpose, such as to harass. And so if you violate that in some way by, in the worst case, let's say falsifying evidence, or in some cases bringing a complaint that you really knew from the outset could not succeed based on the three elements of paragraph 4A of the UDRP, you may be found, or your client may be found guilty of reverse domain hijacking. And I also want to add that professional representatives, such as attorneys, are held to a higher standard. If a complainant, a brand owner, is appearing pro se, they're not out of the woods, but professional representatives are held to a higher standard because under the quote of a decision that we've mentioned in the materials, the Pick Enterprises case from 2012, the panel said that professional representatives should be at least minimally versed in the policy, the rules, their scope, and their limits. It is no excuse that a party or its representative is unfamiliar with clear policy precedent, much less the clear language of the policy and the rules themselves. So I'd defer to Zach here to talk about what are the implications of a finding of RD&H, because that's also a subject of great debate right now.
Right. Well, I mean, one of the purposes of our presentation here today is to give you some of the tools to avoid the embarrassment of your case being found to have been an attempted reverse domain name hijacking case. And we're going to circle back to discuss RD&H in more specific terms at the end, but I want to touch on something that Jerry said, and that's that a UDRP complaint is tantamount to a motion for summary judgment. And the reason that we're emphasizing that to you is that you may believe that it is a tick the box kind of an exercise, that there's some forms that you could fill out that you just need to write out or recite by rote the test under the UDRP, and that is a sufficient complaint. Although it is an administrative procedure, after 22 years of the UDRP, there's some substantial expectations of counsel about how they present the case, particularly of complainants. There's no excuse any longer for not being familiar with the case law and the established interpretations of the UDRP. Otherwise, as Steve mentioned, a panel may very well say that you ought to have known that you couldn't have succeeded in this case had you been aware of the interpretations of the UDRP as espoused by 22 years of jurisprudence.
Yeah, and I would just add that there are no second bites at the apple here. The rules do provide for additional pleadings, but it's only at the request of the panelist. And I will tell you that these are highly disfavored. Panelists very rarely request this. So you really don't have much of an opportunity to add anything new, unless, of course, the response, if you're a complainant and then the response raises new information that could not have been available to you at the time. So as a complainant, you are expected to anticipate the defenses that are going to be raised in your case. And by extension, you're expected to assess a case in advance and not bring a case that could have a substantial defense.
I will note, though, on this, it's Rule 12, where the panel can request further statements or documents. The problem, and some panels actually utilize Rule 12, but there is a problem because where you have deficient complaints, the exercise of Rule 12 gives the complainant an opportunity to make up what it failed to do in the complaint, and that is tantamount to putting the finger on the scale of justice in favor of the complainant. There is one opportunity to make your case, and if you don't make it, it's likely the complainant can lose. And this is the reason why I have said that there are evidentiary requirements, evidentiary demands. You have to meet those demands, and if you don't meet those demands, you're not going to be looked on favorably by the panel.
Indeed, I mean one thing that we often see in UDRP cases, and this it's natural for attorneys, lawyers to expect that there's a right of a rebuttal or reply with pleadings, right? That's how it is in court, generally speaking. There's the complaint, there's the defense, and then there's a reply. There is no reply in the UDRP absent exceptional circumstances. Exceptional circumstances are things that you didn't know or had no reasonable way of knowing, and maybe the respondent raised it in the response. And so that's why Steve's saying you must anticipate these things, because there isn't generally a right of reply.
Yep. So let's move on then to the first element of the UDRP, which is the 4A1, which talks about confusing, the domain name is confusingly similar to a trademark in which the complainant has rights. Jerry's talked about the burden of proof. In this particular element, it's more of a threshold question. It's really sort of a standing requirement, if you will. And there's two components of this. One is you've got to show that the complainant has trademark rights. And number two, you have to show that the domain name is confusingly similar to that mark. Now, a lot of people talk about the timing of trademark rights in relation to when the domain name was registered. That is critical under the UDRP, but it's not critical under this particular element. The trademark rights can arise at any time, and the confusing similarity is independent of that timing. We will discuss that issue later, particularly under 4A3, which relates to bad faith targeting. But for now, just know that the timing between the two is not particularly critical. And Jerry, I think you were going to talk about, well, first of all, I guess it's obvious if you can submit a copy of a trademark registration certificate, from a national authority, then great, you've proven your trademark rights. But I think, Jerry, you were going to talk about proof of common law rights where that registration may not be available.
Yes, and this is a particular problem. Where you have a registration, you are automatically privileged to have standing, assuming, of course, that the corresponding domain name is either identical or confusingly similar to it. But with common law rights, you actually have to prove that you have what's called secondary meaning to the mark that you're claiming, and if you don't, and that requires evidence of reputation at the time that the domain name was registered. And if you don't have any reputation, or you can't prove that reputation, you will be found not to have standing. So what's critical here is what kind of evidence would one have to show in order to demonstrate that one has common law rights? What do you do? Well, there's social media. There's independent reporting in commercial magazines and newspapers and so on. Zach, you have
customer reviews are also very helpful.
Customer reviews and so on.
Yeah.
All of this has to be one of the things that we should mention in terms of the complaint, and in terms of the summary judgment aspect of it, is that you're actually looking at a package. It is a complaint, but it's the kind of it's both the complaint and also, if we compare it to summary judgment, if we think of it as summary judgment, is a combination of complaint plus motion for relief. And if you think of it in that sense, as a motion for relief, you would understand what the proof must be that's a part of the package that's being conveyed to the panel. But with the common law rights, if you don't have that, you don't have standing, and the complaint can be dismissed.
Yes, and so the kind of material that Jerry's mentioned goes into the annexes, of course, but it's, you know, what we often see is that, you know, let's say that your client doesn't have a registered trademark right, but it has a claim for common law trademark rights. The way to address that isn't to simply make a claim that the complainant has common law trademark rights. It's also not enough to just attach an affidavit that says, you know, I verily believe that my company has acquired common law trademark rights. It's not enough either. Maybe you don't need consumer perception surveys in all cases or most cases, but you really need to bolster your complaint with these annexes, historical media reports, the social media that Jerry mentioned, et cetera. And the onus and obligation, or the difficulty rather, of proving common law trademark rights is in proportion to how distinctive or descriptive the term is. And bear that in mind as well. So you want to put in more evidence, the same way you would prove common law trademark rights in a court proceeding if the mark had descriptive qualities and you want to displace those with a secondary meaning.
Yeah, these are all great points in terms of proving that you've got these rights. So let's move on to the question of the second part of 4A1, which is proving that the domain name is identical or confusingly similar to the mark. Identical generally means apart from the TLD itself, the top level domain. So you can take off the .com, .net, .store, what have you. Although we've seen some cases where it is relevant, most of the time you don't necessarily need to look at it. So the identical means, let's say it's, you know, the mark itself, dot, whatever. More interesting, of course, is what is the standard for confusingly similar? And the bar for that standard it's not particularly high. As we said, this is sort of a standing requirement, a threshold requirement. So if the mark is somehow recognizable within the domain name, this element could be satisfied. We've included, for example, the BBDO West Africa case in the materials, and the mark is BBDO, and you can see that they add additional terms like West Africa. So adding a geographic term, adding a descriptive term to the mark, it does not reduce the confusing similarity. In fact, if you add words that are directly related to the complainant's field of business, you may actually enhance similarity or confusion. There's the next case we talked about was the Walbro engine management case. And here they added the word fuel and pumps to the Walbro mark. And, that actually enhances confusion because this is a product that is made by the complainant.
Yes.
I would, go ahead, Jerry.
Yeah. No, go ahead, Zach.
Yeah, no, I was just going to add that, one possible more intricate issue when it comes to confusing similarity, and it doesn't arise all that often, is that if you have disclaimed the word part of your design mark, that could make it difficult for you to argue that the mark is confusingly similar to the domain name, because you really don't have a trademark that has rights in the registration. You might have to prove common law rights, for example, outside of that registration in order to prove the common law similarity.
And of course, you can also have the situation where there is similarity, but the similarity is not confusing. It just turn it around, and you can lose standing by by the similarity not being confusing.
Yeah, that's an excellent point. I'm sorry, go on, Zach.
Yeah, no, I was going to say something. It's an excellent point. I mean, there's a whole line of cases, even in the courts as well, that say small differences matter when it comes to similarity of domain names and trademarks in the internet environment. But, you know, generally speaking, as Jerry and Steve said before, this is a pretty low threshold under the first part of the three-part test. Most panelists, if you have a trademark and a reasonable claim for common law trademark rights and it's reasonably confusingly similar, they're going to pass along and go on to the second part of the test, which is, I guess, what we're about to do now ourselves.
Yep, let's move along, I guess, to paragraph 4A2, talking about whether or not the respondent has rights or legitimate interests. And this is also a very interesting area, because you're basically trying to ask the complainant to prove a negative. Obviously, we all know that's very difficult. So the standard is that the complainant need only make a prima facie case that the respondent has no rights or legitimate interests. And it then flips, the burden then flips to the respondent to show that they do have some rights or legitimate interests. Now, when I say the burden flips, I want to be very clear here. When a respondent defaults in a case and fails to appear, they are not automatically, they don't automatically lose the case. As panelists, we are mandated to review all of the merits of the case, regardless of whether respondent appears or not. And there have been a number of cases that have been denied, or even where reverse domain hijacking has been decided, where the respondent never even showed up. So another bit of the cautionary tale here. So, Jerry, I don't know if you want to talk about some of these examples of.
Well, no, but I would add in terms of this element, and where the respondent does not appear. The problem here is silence. If a party is silent, the narrative is solely from the complainant. All you know is what the complainant tells you. So silence is in fact, even though the panel is cautioned not to make a determination on default, that we look at the merits and all of the evidence. The evidence, in fact, in this element is solely from the complainant. So silence is in fact a significant factor in making a determination as to whether or not the respondent, the registrant, has rights or legitimate interests.
Yeah, you know, I would kind of compare the situation for those watching that practice litigation and they obtain a default judgment in court, and it's for not a liquidated damage, as it's referred to in Ontario courts, for example. So you then need to bring a motion under the Ontario practice, at least, and probably in similar jurisdictions throughout Canada and other parts of the world, perhaps. You need to go convince a judge that you're actually entitled to the relief that you've requested, if it's not strictly speaking monetary damages. And so you're really, that exercise is similar to what you're engaged in here as complainants counsel. You'll still need to convince the panel that you're entitled to the relief that you're seeking, although it's going to be a little easier for you because there's no one who's given a counter narrative, but you still must treat it almost like an ex parte appearance in front of a panel, so where you have, you know, a duty to be forthcoming and complete with all the facts and still prove the case. Of course, the panel will be able to draw some adverse inferences from the failure of the respondent to respond to the pleading.
Yes, it's ironic. Where the respondent does not appear and is silent, the kind of evidence that's proffered is really quite low. to demonstrate that the prima facie case has been satisfied. Steve.
Yeah, I agree. I mean, the respondent really doesn't need to produce a substantial amount of evidence, but they do need to produce some. And if you want to go through some of these examples, the most common one that people talk about is under, and by the way, paragraph 4C of the policy provides three examples of how a respondent can show that they have rights and legitimate interests. The most common one, it talks about they're making or they're preparing to make a bona fide offering of goods or services, meaning that they're making some legitimate actual business use of the domain name. This could be that they're running their own business. It could mean that they are running I guess a fan site would be more under fair use. But it's basically that they are making some kind of legitimate, even if it's for profit, it's some kind of legitimate use of the domain name. One of the sort of seminal cases in this area is from 2001, sort of the early days of the UDRP. And it's a case involving the complainant Okidata America, and it's in your materials. The scenario is basically okidataparts.com was the domain name. And the respondent was claiming that they are just an aftermarket seller. They are unofficial, they're not authorized by Okidata, but they're a seller of parts and supplies for Okidata printers. And the panel in that case devised a 4-part test for whether they were making a bona fide or fair use, if you will, of the Okidata mark, even though it was for profit, it was commercial. To very quickly summarize, they talked about, does the site actually offer the goods or services at issue? Does it sell only the trademark goods? In other words, not any goods of complainants' competitors. Does it accurately disclose the respondent's relationship with the trademark owner? In other words, is there a prominent notice of non-affiliation and that they're a reseller? And finally, do they try to register multiple domain names copying the trademark where they're trying to, quote, corner the market? And in this case, the panel found that all of these elements were met. And so okidataparts.com was allowed to remain with the respondent, notwithstanding the fact that it very clearly copied the trademark. So that's one example of, I guess, a bona fide use in commerce. The next one is about being commonly known by a domain name, and Jerry and I were co-panelists on a case involving this commonly known by situation. Jerry, if you want to talk about the D'Agostino case, perhaps?
Yes. So in New York, there's a supermarket chain called D'Agostino, and D'Agostino was the complainant in this case. The respondent was also a D'Agostino, living in Philadelphia, I think. So the question here is twofold. That the respondent has registered its family name, and that fits squarely into 4C2. The complainant ought to have known this, and having known this, it ought not to have brought the complaint. And because it brought the complaint, where there was, in essence, an affirmative defense, it was sanctioned, and we'll talk about that. A more recent case, and I think a more interesting case, is a case that I think we also have on this list that just came down, Bartco. Bartco, in a sense, Bartco v. Bartco. Bartco is a law firm that's reputed to be an IP, a distinguished IP law firm, and yet, as Zach pointed out, there's the equivalent here is that it's a shoemaker without shoes. Here again, we have a situation where a complainant is commencing an action, a special proceeding against a party who has registered a domain name that represents his family name, and also sanctioned.
You know, most of, I think, the statistics are that something like 94% of cases aren't even defended. And that kind of, those 94% cases approximately that aren't defended are what can be called clear-cut cyber squat cases. And in those kinds of cases, the complainant's counsel's obligation to make supported allegations of the respondent having no rights or legitimate interest isn't that heavy a lift. So, if you're representing Citibank and the domain being disputed is my Citibank login, which is my favorite example, I always use it. You're able to recite, the boilerplate almost. The respondent isn't known by Citibank. The respondent isn't using it for a non-commercial thing. The respondent has no trademark registrations in it. And then the respondent, in theory, is able to rebut these things, but rarely will if it's a case like that. Where it gets more complicated is when the name isn't necessarily a clear-cut cyber squat, but yet the complainant still believes under the UDRP they have a righteous complaint to make for the transfer of that domain name. That's where complainant's counsel really needs to examine how much evidence they're able to marshal under the legitimate interest test in advance of the respondent's response. So, and it's also important to note that the examples are just that under the policy. They're not exhaustive. So one of the kinds of rights or legitimate interest that isn't specifically enumerated in the policy under rights and legitimate interest is investing in domain names, for example. There's some law that will say, well, it's not, there's no rights or legitimate interest even in a dictionary word domain name unless it's used in the dictionary sense of the word. So if it's caribou.com, you must be selling caribou there, for example. But other case law, and I would suggest most of it. I would say it's fairly much the consensus view that there is a natural or arguably automatic right and legitimate interest to register those domain names on a first come first served basis if there's no evidence of bad faith accompanying it. And so we'll talk more about the registration use in bad faith shortly, but it's the point being that rights and legitimate interest needs to be examined much more carefully in a case that you anticipate being contested.
Yes, I think when the complainant is looking at the domain name, it has to question whether or not it's possible that the selected name, although it may be either identical to or confusingly similar with, could also have an association independent of the complainant's mark. So, for example, in the caribou that Zach mentioned, and there's much law on this as to what they call professional domainers who have a market presence. They're recognized as having legitimate businesses. As long as the selection of the name Caribou, for example, has not been acquired specifically for the purpose of taking advantage of the complainant's mark. So in the Caribou case, which incidentally Zach was the representative, was the respondent's representative. You have a situation in which the parties are located on separate continents. One of the issues is how could it be that the respondent could have had actual notice or actual knowledge of the complainant who was located in the UK, where the respondent was located. I think Zach, remind me. I think it was in the Middle East. So all of these are questions that have to be answered. Where you have the kind of clear-cut situation that Zach was talking about, those cases are indefensible, and for the most part, over 90%, those cases that are indefensible are rarely defended. So we're not really talking about that kind of situation. But in terms of the rights and legitimate interests, what has to be focused on is what does the prima facie case amount to? Well, basically, it amounts to, it's the reverse of 4C 1 to 3. It's the reverse. So what the complainant's counsel actually in drafting the complaint, what it's going to be saying is that there's no conceivable way in which this domain name can be used except to infringe us, or alternatively, the respondent is not commonly known by, and then the third one is that it's not using it for any purpose. So, I mean, that's basically what we're looking for. But in the best complaints, I think we can say this, in the best complaints, it goes beyond that. It puts to the panel everything that can be said in terms of evidence that would cause the panel to conclude that the complainant is right in terms of rights and legitimate interests.
Yeah, it's that balancing of burdens, and as Jerry said, there are debatable issues as to things like domain name investing, whether that's an inherently objectionable activity. I mean, we've cited a case in the materials basically that says it's not inherently objectionable so long as they're not encroaching on the trademark rights, so long as there's no targeting. And we'll get to targeting in a little more detail later. But I also want to talk about this fair use issue under 4C3, because that is also commonly shown, or at least there are attempts to commonly show that a respondent is using the domain name in a non-commercial, legitimate, or fair way. And when I say attempts to show, let's face it, some of these cyber squatters are not always the most ethical and the most honest folks. And so you see all sorts of, rationale that are put forward for domain for domain uses. There was a case some years ago involving the domain name Dunkin.menu, and the complainant was Dunkin' Donuts, and menu they asserted related to the the menu on their donut and coffee shops. And the respondent said, "Oh, no, I operate in New Delhi, India, and I provide a series of basketball courses, clinics at various high schools. And I talk about Dunkin' the ball. And so I provide a menu of different strategies for Dunkin' the ball." And this guy went so far as to produce these fake posters that he claimed had put up in all around these different high schools. And the representative, the complainant's representative, actually called a bunch of these high schools and found out that none of them had ever heard of this guy, and some of them didn't even have basketball courts. So you've always got to be a bit careful. One of the cases, though, that they talk about is fan sites. That's generally considered legitimate nonprofit if you are a fan of the brand or if it's a celebrity. But you have to be careful. Just claiming that it's a fan site doesn't cut it. You have to show that you're actually using it. And we've cited one of the cases, the Liverpool Football Club case, in which the site was inactive for quite a long time. And basically the panel said, I don't really see any evidence that this is a legitimate fan site here. So again, evidence. It always comes down to that.
Those are all excellent points. I like that case you mentioned, Steve. We should probably go to bad faith registration and use if Jerry wants to lead us there.
No, why don't you start off, Zach?
Well, bad faith registration use, it's conjunctive. Both are required under the policy. I'd love to hear Jerry and Steve's thoughts on this, but in my view, the essence of this part of the test is targeting. And in fact, the essence of the entire UDRP is targeting, because the policy is premised on trying to go after and transfer domain names that are registered because they're trying to interfere with the complainant's trademark or trying to prevent the complaint from reflecting its trademark in the corresponding domain name. All of these things infer awareness of the complainant and the complainant's mark. That's really the basis of cyber squatting, which you could differentiate from not having any knowledge of the complainant, but yet maybe it's being used in an infringing manner. And that's an infringement situation that can be addressed in court, perhaps. But within the context of the UDRP, the cases and the policy really tries to go after those domain names where, to use the Latin phrase, the respondent's trying to screw with the complainant.
I'm going to ask you to conjugate that verb at some point in Latin. Yeah, I mean, the crux of a lot of bad faith arguments is targeting. We mentioned that earlier. And as Zach mentioned, it's a conjunctive. You have to prove both registration and use in bad faith. There are other country level domain names that have their own dispute policies, and some of them use the word or, bad faith registration or use. But with the UDRP, we're stuck with and. So it's critical to prove that the respondent was specifically targeting the complainant's trademark at the time that they registered their domain name. And so one of the things that we see very often, and this is a real problem with some cases, I talk about these cases that are otherwise winnable. A complainant will say, oh, my trademark is the most famous in the world. Our brand is known by everybody everywhere. just ask anybody on the street. We have, millions and billions of dollars in sales, and we spend all this money on advertising, and we've been recognized, and we're just so famous. The respondent must have known about us when they registered the domain name. And then as evidence, they will submit copies of their trademark registration certificates, or maybe at the most, they'll submit a copy of their own website. And as a panelist, you kind of scratch your head and say, you're claiming all of this grand reputation, but you're just giving me evidence that you have trademark rights. If you were to appear in court and say, our brand is the most famous in the world, and as evidence, here's a copy of our trademark registration, what would the judge ask you in that moment? Do you think the judge would look at the registration and say, like, oh yeah, sure, it's famous, all right? You've got to submit, you've got to show that reputation. And Jerry talked about this earlier in respect to proving common law rights. It's not enough to just show that under bad faith. It's not enough to just show that you have rights. You've got to talk about how much, show us examples of advertising. Show us, how is your mark so prominent and exclusive within your industry? Show us news articles. Show us, social media. Show us, reviews that customers have posted. You've got to show in some way that the respondent knew of your mark. Now, the other way to show is actual use. If the website of the disputed domain name is clearly, it's got your logo all over it, it's offering or claiming to offer your products, maybe it's some kind of scam that's trying to impersonate the brand owner. Okay, in that case, it's sort of a given that they had notice of your brand at the outset, because their use shows it. But the more interesting and more often the cases are where the website content is not definitive in those situations.
It's interesting, Steve. You started your comments with the comment that we're stuck with the and. The fact is that the UDRP as we have it was originally proposed. Well, it was the brainchild, in a sense, of commentators with the World Intellectual Property Organization. It started out in the concept and all of the ideas were presented to ICANN, who put it into a code form. What we have with the UDRP is a code that provides that in order to prove cyber squatting, you have to do both registration in bad faith and use in bad faith. One of the things that has come about and that both complainants and their representatives don't quite understand is where you have a situation that the mark postdates the registration of the domain name. It's somewhat anomalous because under the UDRP, if you have a trademark, and it's a registered trademark, you have standing. Even though you don't have an actionable claim. So when we reach the third elements, the third requirement of the UDRP, we have a situation in which the complainant is saying that this respondent is using this domain name is using it in bad faith. But of course it doesn't meet the objectives of the UDRP. because it could never have been registered in bad faith. So that gets dismissed. It simply doesn't have an actionable claim. One of the things that we have to look for is both that the complainant has the burden of proof, but we also have to understand that the respondent it doesn't have to be silent. It doesn't have to be silent. It can actually make a case, and it's allowed to make a case.
Right. So, I want to talk a little bit about the chronology and timing issue of bad faith registration and use. So, in order for there to be bad faith registration under the policy, the domain name must have come after the trademark right? Because otherwise, how do you register the domain name in bad faith to target a complainant when, for example, the complaint wasn't incorporated then, or the trademark wasn't even the twinkle in the eye of a complainant when the domain name was registered. So if you have a trademark registration that you got last week and the domain name was registered by this particular registrant 10 years ago, you're out of luck under the UDRP. But suppose you have common law trademark rights, which came a long time ago, maybe before the domain name was registered. If you're able to prove the common law trademark rights accrued to you prior to the domain name, then you might have a case to make for bad faith registration use. And so, although under the first part of the test, we talked about proving the common law trademark rights just to get standing, under the third part of the test, the bad faith registration use, the goal of proving the common law trademark rights is to identify when they accrued. Often that's difficult to do with precision with common law trademark rights, but you'd want to at least make your best attempt to demonstrate through evidence that prior to the registration date, you had common law trademark rights. And this gets back to what Steve and Jerry are saying about reputation, because even if you prove that you have common law trademark rights that accrued before the domain name registration, where you still need to prove targeting. That's where the reputation of the brand comes into place, right? Because you need, if the registrant is across the world in Dubai and you're in Michigan, you need to say that you advertised in Dubai, or you may have press releases, or you have customers or website access there, etc., all prior to the domain name registration, so that the panel is in a position to possibly infer that the respondent either knew of you or certainly ought to have been aware of you.
Yeah,
I think, Steve,
go on, Jerry.
Because I think we need to move on to the, because I see the time is 3:58. Unless I think we should probably move on to the RDNH.
Yeah, that's fine.
Yeah, why don't we just spend a few minutes on that before we move to questions?
Well, I actually was going to talk about RDNH in the context of this vacation pig case. It's listed under the bad faith section of the materials, but it applies equally. This was a situation where you had the domain name predating the mark. There were many other factors involved, but what was interesting was that the complainant tried to argue that a renewal of the domain name during its grace period, which occurred after the trademark rights existed, but they tried to claim that renewal of this domain name during the grace period started the clock all over again, and therefore they could show that their trademark rights predated that renewal. This was one of my cases, and basically I said this, sorry?
As the panelist, it was your case.
Yeah, this was one of my cases as a panelist. And I went through the various ICANN and registry rules about the grace periods. And basically the complainant was making a really unwinnable argument. But then even if they had proven that the mark predated the domain name, they had lost on so many other grounds. The domain name never displayed any content that touched on the complainant's field of business. The respondent never offered to sell the domain name to the complainant. And then in fact, when the complainant approached the respondent to try and buy the domain, it never identified itself as the complainant. It approached itself through some agent and may have actually lied to the respondent, saying that they were starting up a company. So basically, I found RDNH here because this really it just failed on so many grounds that the complaint really never should have been brought.
And the domain name, Steve, I think was uvo.com.
Yeah, oovo.com, exactly.
And uvo has a meaning?
I don't recall that from the case, but it really almost didn't matter. It was the complainant did have rights in the trademark. It's just that, as I said, they post-dated the original registration of the domain name, and they failed on so many other grounds. So, but I don't recall if there was a specific meaning of the word.
Right. So even if the name was a coined name, it wasn't coined by the trademark registrant.
Yeah, exactly. It was coined by the registrar, the respondent, way back when they first registered the domain name. Exactly.
Well, I would just say, so we're talking about RDNH, reverse domain name hijacking, and here we have the situation, two kinds of situations. One, that the complaint was brought was itself an abuse of the UDRP policy. The other part of the RDNH is that there is no conceivable way, and I think this is what Steve was talking about with the uvo.com. There is no conceivable way in which the complainant could have argued bad faith on the part of the respondent. And that's deserving of a sanction. And that's basically what we're talking about with RDNH. It's a sanction. It has no economic penalty. But nevertheless, we have discovered that, notwithstanding that it has no economic penalty, it's a very desirable consequence of the complainant's action.
Yeah, it's not something you want.
No, it's not something a complainant wants. But we also know that the respondent doesn't actually have to ask for the RDNH. It's a sanction that ought to be considered by the panel. And indeed, RDNH has even been made by the panel, even if the respondent defaults. So you have a situation with a defaulting respondent, notwithstanding that the complainant has not shown its case, but the complaint ought never to have been filed.
Yeah, RDNH, is something to be avoided, but it comes in many different forms. It's not just one kind of RDNH. One kind is when a complainant or its representative isn't familiar with the policy and can get sanctioned for that, or makes arguments that have long been rejected under the consensus views in the jurisprudence, or is misrepresented or overstated trademark rights, or failed to disclose evidence. All these kinds of things can be RDNH. One kind that comes off, I would say, with greater frequency perhaps than some of the others, is what we call a Plan B RDNH. And Plan B RDNH is almost a term of art used by panelists because it refers to a specific kind of reverse domain name hijacking. And that's the loose definition of it is when the UDRP is used by a complainant as a substitute for a commercial negotiation of a domain name and resorts to the UDRP after the failure of those negotiations. Now, that's to be differentiated from a circumstance which, as a complainant's representative, you might make a nuisance offer to the respondent, or say, I'll give you your out-of-pocket expenses if you transfer the domain name, or a settlement out of expediency, and care must be taken with how you do that, because but that's a different situation than when you see a descriptive or a dictionary word domain name that long predates your trademark rights, and you offer $5,000 for it, and you get met with a $100,000 offer, and then you bring the UDRP saying that the price was too high, or they refused to negotiate with me, or they're not using the domain name, or I have a brand, my business is more important than this domain name investor, et cetera. Those are the kinds of things that can add up to a Plan B RD&H in the case law.
Yeah, it comes up way too often. And again, this is one of those moments where, practitioners sometimes confuse UDRP strategy with litigation strategy. Sometimes people will bring a very loosely premised litigation because they feel that they will bring pressure on the defendant to settle the case, or it'll force the defendant to spend money on legal fees, and it'll give them leverage. UDRP is not like that. As we've said, there's no requirement that a respondent participate in the case, and there are oftentimes cases that are denied even on default. So in a Plan B case where the negotiation fails, the respondent is asking too much money, the complainant then files a really poorly considered complaint, thinking they're going to bring pressure on the respondent. More often than not, it backfires, and what can happen is at the end you lose that case as a complainant, and then you go back and try to reopen negotiations, purchase negotiations with the respondent, and you can imagine the price has just doubled at that point, because they know that you've got no leverage on the legal front. And just as a sort of tragic, humorous aside, if Plan A and Plan B fails, for goodness sake, please don't ever try Plan C. This was a story in the news about 3 or 4 years ago, where somebody tried to negotiate a purchase of a domain name, couldn't get it done, and literally went to the domain name owner's business and forced them to transfer the domain name at gunpoint. So that's Plan C. We do not recommend it. As you can imagine. And
the CII-DRC doesn't offer that service either.
No, the CII-DRC does not offer this as well. But you can imagine this guy is now spending some time in jail. Thankfully, no one was hurt. And the domain name itself was unscathed. So don't try that.
Well, we have 20 minutes left for some questions or some other remarks.
Yes, and I've noticed people have been submitting some comments or questions in the chat function. I don't know if our panelists have had a chance to see those. You've been too engrossed in the discussion and the presentation probably, but I can assist and go through some of these, starting at the first one that came in. Were you surprised by the forced transfer of France.com, owned by an active business and trademark holder, to the Republic of France on grounds of sovereign rights to matching domain? And what does this mean for domain registrant owners of similar geodomains? Or does it mean nothing? For say someone that might want, someone that does own Germany.com or Spain.com. Anybody want to take a stab at that one?
Well, I don't know that much to be said about this. This didn't come from a UDRP. It came from a legal action in Europe, and specifically in France. And in France, they have some statutory law on the use of the word France and other things. But it's not a UDRP issue. So I don't think there's much more to say about it on that. The kind of UDRP issue that we have had is Barcelona.com, for example, where the where the panel in Barcelona.com awarded Barcelona.com to the complainant. And that was appealed in US courts under the Anti-Cyber-Squatting Consumer Protection Act, and the award and the UDRP award was annulled. That's the kind of case that we're looking at. France.com is not, you know, I don't think there's anything more to say about it. Steve?
Not really. I'm looking at the case right now, and the complainant was based in Barcelona, Spain, but the respondent was based in New York City in the US. So the fact, and by the way, I don't know that we can make much from the name of the panelist, Marino Porzio, but it could be that this case was more influenced, this UDRP case was more influenced by European view of the law, whereas, as you mentioned, the appeal was to US courts that, you know, that recognized that the genericism or the geographically descriptiveness of the name.
Yeah, I would just add that generally speaking, the case law demonstrates that geographic domain names like Barcelona.com, like Paris.com, etc., these names are generally protected under the UDRP. Most cases go in favor of the respondents on those kinds of cases. We do often see them arise. Sometimes you'll see like a tourist board say, you know, we're the ones that should have this domain name because it corresponds to our town, our country, our province, our state, etc. And those cases generally result in failure for the complainants under the UDRP.
Okay. We do have a number of additional questions. I'm just mindful of the time. One question that comes up, and we did touch on it in the presentation, but maybe we could just elaborate a bit more, or maybe more succinctly. You know, it appears in some cases, some decisions, that investing in a domain name is a legitimate use, and others seem to take a different view of that. Do you care to comment? Is there a consensus view on whether investing in domain names is itself a legitimate use?
Well, I see that one of the comments later on, I'm not sure if this is the one you were referring to, specifically addressed the question of investing, but then asking for a very high price for a domain name. And some panels will sort of zone in on paragraph 4B1, talking about an attempt to sell the domain to the brand owner at a price that's greater than out-of-pocket costs. I think we've talked about this at great length amongst the three of us. The price alone should not be the factor that decides bad faith. If you have, applesales.com and you're offering it for sale, it really depends on what again, it comes back to targeting. If you've owned that and your family has owned that domain name for a couple of decades, and you have an apple orchard in the state of Washington, and you've been selling apples, that may show that when you registered it, you had a good faith use for it. Even if you are in fact targeting the Apple technology company in your current sale. So I think it really comes down to, I think, yes, domain investing is in the abstract is a legitimate business, but it really comes down to what are the circumstances of the case, and was the respondent specifically targeting the brand owner. We've talked about the one case where the complainant was the one that initiated the sale discussions. That may indicate that no, they were not targeted because they themselves started the sale discussion. And so when the respondent asked for a high price, it wasn't because they were reaching out to the brand owner. Sometimes the brand owner will reach out and they'll do it anonymously. And that way the domain owner doesn't even know they're dealing with the brand owner. So you have to look at all the circumstances.
Jerry, you literally wrote the book on this. What do you have to say?
Well, the consensus view is that it's actually called arbitraging. The consensus view is that buying low and selling high is not condemned by the UDRP. I mean, I would say that. I mean, ultimately, we've had this discussion. We've had this discussion in the U.S. federal courts also, and we have a particularly good case actually from 1999. Just about at the time that the UDRP was being promulgated and the ACPA was being signed into law by the federal court actually recognized that domain names that have independent value, separate and apart from any value that the trademark owner has, is not to be condemned. And the UDRP and the consensus under the UDRP is that professional domainers have a business presence in the market, and that it's legitimate. Now, the kinds of cases I think this the person who asked this question is actually pointing to are the kinds of cases in which some panelists look at the dollars that the domain name is being valued at, and use that as a factor, as Zach said. It is not a factor. The consensus is that it's not a factor. Nevertheless, there are panelists who have taken the position that it could be. In the particular case that I'm thinking of, and I forget, it's a three-letter domain name. The award was challenged in federal court under the ACPA, and the award was cancelled. So I mean, that's the kind of experience. Now, when those cases go to federal court, panelists follow the federal cases. They know what's happening. I don't suspect that we're going to have that kind of case again. I've had experience in other situations where you have in a 3-member panel, for example, where one of the panelists has a totally different view of what the result should be, what the outcome should be, but his view has been educated by a concept of infringement that has actually been rejected by other domain panelists. So my view is you know, it always depends, as Steve said, on the totality of facts. One supposes that even with a dictionary word that a respondent believes has value, depending on the totality of facts, it may be that even the dictionary word is not only confusingly similar to or even identical to, but in fact infringes the right.
Right. In fact, we saw that with the case of Halifax.com several years back, where, you know, that is a geographic term, important country, I believe the last name as well, probably a location in other places. And the respondent was found to have engaged in cyber squatting, lost to UDRP, because although someone else could have registered in good faith, he didn't happen to, because he was immediately started using it for content related to insurance services, and Halifax Insurance was the complainant, and there was solicitations, if I recall, as well. And so under the circumstances of that particular case, the panel was able to say, listen, maybe Steve or Gerald could have registered this in good faith and used it in good faith, but this name is going to be transferred because it was registered to target this particular complainant.
Okay,
Yeah,
we maybe should move on to another topic.
Yes,
We have
please.
quite a few remaining questions, not much time. Just looking at a question that came in, what independent research can a panel conduct if there is no response, if the respondent doesn't respond? Can the panelists look at the website? Can they look at the Who Is registration, look at archive.org to see whether the respondent did, in fact, have a legitimate interest? And what if the domain name matches the last name of the respondent in the Who Is?
You know, it's interesting, Barry, on this particular question. We've already seen two situations in which the respondent's last name or family name matches the domain name. In those situations, there's actually an affirmative defense. I don't see that can go anywhere. Steve, I
just wanted to backtrack to the question, because I just want to explain that it is in the rules that the general powers of the panel can in fact conduct independent research. The real question, I think, comes down to you touched on this earlier, Jerry, about how much is, sort of peripheral independent research. Maybe you want to verify, that a trademark registration exists, so you go to the trademark office website. That could be one element, but how much of it is tipping the scales? How much of it is where, you are actually doing the homework that should have been done by one of the parties or their representatives? As UDRP panelists, most of us have started out in some form as representatives and party representatives. And so we know how this is supposed to be done. We know the proper evidence that's to be submitted. And so you have to guard against reading a complaint filed by someone else and saying, they should have put this in, or they should have put that in, or if I had filed this complaint, I would have done this differently. And so you really have to guard against that potential drive to say, well, I'm going to go look this up. I'm going to, you don't want to spend an hour online on Google, researching the reputation of the complainant when they didn't put in their own evidence. So to that extent, I would say that's too much research. But yeah, to just confirm a minor fact, or let's say, the screenshot that's submitted of a particular website is just, a little grainier, it's unclear. Is it okay to go to that, browse to that website just so you can see a more clear image of it? I'd say, yeah. I don't know if Zach, do you have any?
Yeah, I think that the reason that panels are appointed is not just because of their experience, but because of their judgment. And so we expect panels to exercise good judgment. And under the rules, as you pointed out, they're empowered to conduct some research, but how much is a matter of judgment in the circumstances? It's especially when a case is undefended, a panelist may be inclined to, question the complainant's case because there's no adversarial system in order for the facts to be shown, right? That's an example where panels might be tempted to conduct some verification of the complainant's arguments. Also, as Jerry mentioned early in our conversation, under the rules, a panelist is empowered to request more evidence, make essentially a motion to say, Mr. or Mrs. Complainant, I was a little unsatisfied with the evidence you put in. Could you put in something more? Give me something to work with here, right? That might be a procedure instead of the panels independently conducting that investigation, him or herself.
Of course, a part of the question here is what if the respondent doesn't appear, and what can the panel do? Can it do its independent? Can it do some independent research? Because there's only one narrative. There's only what's coming in from the complainant. If you get a complaint that sets out a story that supports the argument of infringement, the panel can exercise some independence in looking, for example, at the website that the domain name goes to. It can look at those things, and it might in looking at those things, and or even looking at the trademark, going to the trademark office and looking at the data. It may find that the statements made in the complaint are inconsistent with some of the things that the complainant is saying. That is legitimate, and it could very well result in a dismissal of the complaint if the panel finds that the complainant is making statements that are insupportable when you go to look at the facts. I guess, can we go on to the next question?
Well,
Do you have another one?
We have some questions that came into, not in the chat function, which we've gone through, but also the Q&A function. Okay. And there's 3 there. So let's take a quick, we have 3 minutes remaining. I'll start at the bottom. Is it worthwhile having anonymization be a factor that could tend to indicate bad faith?
How about I answer that one really quickly? It's an easier question. Because of GDPR, which is a policy in Europe, which compelled, or at least registrars believe they were compelled to withhold who is particulars in many cases, the data we're able to get from who is unhelpful in most cases, and also by default, many domain name registrations are anonymized. And so it used to be that if someone actively went out and sought to get an anonymized registration, that could be an indication of bad faith. These days, it's seldom, in my view, looked on by a panel to be an indicator of bad faith when it's really the default.
The one exception I would give is when we call it sometimes the Matryoshka doll situation, where the registrar itself will hide the information because of something like GDPR, but then when the information is eventually revealed, the registrar gives you whatever information they have. Turns out that it's another layer of a privacy service, and in that case, I would say, yeah, the respondent is in fact actively trying to hide its identity. That being said, I don't know that privacy alone is grounds for bad faith. I find it helpful as a supporting factor, but not necessarily alone.
Not determinative. Okay, what are some practice tips or pitfalls to avoid for a complainant when there is little information available about the domain registering due to domain by proxy services? Research.
Yeah. It's a difficult one. Like, to be frank, I mean, there used to be a lot more data available through historical WHOIS searches, through searches like domain name tools. That data has degraded over time and will continue to be degraded. ICANN is working on some potential tools to address this gap in WHOIS data. That may or may not happen at any time in the future, but really you just have to use what's available out there. Archive.org, domain tools, even sometimes a letter might get you some information, right? Steve, you do that sometimes.
Demand letters will sometimes yield helpful results, but basically pull on every little thread you can, and sometimes it'll lead to the ball of yarn, but not always. It's a tough one. You're right.
And then lastly, suppose the disputed domain merely shows a landing page that offers the domain name itself for sale. In your view, is this a bad faith use of a mark in commerce?
Jerry, you want to take a shot at that one?
Yeah, Jerry.
Okay, the answer, the consensus here is that it is not by itself bad faith. You still need to look at all of the other evidence, assuming that there is evidence. For example, and this touches on what Zach just said. The complainant doesn't know enough. The complainant doesn't know enough. But it can go to archive.com. And if the domain name has passed through many hands, for example, you can see from archive.com who had it before, who has it now, and so on. And you can get a lot of information about that. But just in terms of, is it bad faith simply by having a parking page? The answer is no. That not by itself.
Right. I would just add that if it's Coca-Cola.com and it's offered for sale, it could be a problem, right? But if it's chairs.com, it probably isn't. Yeah.
Great. Just quickly checking back in the chat, see if there's anything additional. What about bona fide user of matching trademarks by someone in a different country for similar goods? Sorry, the language there might be a bit butchered, but what about bona fide user of matching trademarks by someone in a different country for similar goods? Example, Disco as a clothing brand?
Could be a bona fide offering. I mean, having your own trademark as a domain owner can put an end to a UDRP case very quickly, because then you're showing that you do in fact have some rights or legitimate interests by virtue of your having a legitimate business in your home country.
Okay, I know we're now just over time. One last question that came in a minute after we were supposed to be finished. Do you think that the Arbitration Center's request for underlying who is data to the registrar before commencement of the UDRP proceedings can become a substitute for Norwich orders to find out who is behind a website?
But it's certainly it's certainly a one of the methods by which a complainant gets to know who they're dealing with. It could be. I haven't had this situation, but Steve may have had. That once you know who the respondent is, you decide to withdraw the complaint.
Yes, I have.
Because you can see immediately that the respondent has rights.
It's sort of like,
there's no point. Yeah,
it's sort of like the old Forrest Gump line, the UDRP is kind of like a box of chocolates. You never know what you're going to get, because you file your complaint, and because there are very limited evidentiary tools, you may learn surprising things in the response that might in fact lead you to decide to either withdraw the complaint or perhaps suspend. You can suspend the complaint for up to 45 days under the rules and negotiate a resolution with the respondent. The game's changed. Let's talk.
Yes, that's actually a very good point.
Thank you.
A lot of good points, Steve. A lot of good points, Zach.
Yeah.
Yes.
I've always had a pointy head. Yes.
We've covered a lot of ground here in the last 90 plus minutes. I hope all of the people who have been attending and watching this presentation have found it as informative as I have. I want to thank again our panelists, Zach Moskovich, Gerald Levine, and Steve Levy for their participation today, offering their wisdom and experience for all of us to benefit from. As always, if you have any questions related to what we're doing at the CII-DRC or matters about initiating a complaint or responding, feel free to contact us through our website, ciidrc.org, and we'll endeavor to get back to you as quickly as possible. Once again, thanks everyone for tuning in, and I hope you have a great rest of your week.
It's been a pleasure. Thank you.
Thank you for having us.
Bye now.